Our last case for today is Whitney versus Wilcoxson. Good afternoon. This is a 15-minute mini oral argument on the application. You both have 2 minutes of a free fire zone that you may waive, and you may reserve. Sorry. No, we just replaced those up here for that very reason.
And you're also the second person who did
Today.
that today, so don't feel badly
bad.
about it.
Clean up on.
Just, clean up on Helen's
Council
table.
Good afternoon, Your Honors, and may it please the Court, Dan Labella on behalf of the defendant appellant. At this time, I'd like to reserve 3 minutes for rebuttal. The Court has asked for briefing and oral argument today on a single question, which is whether or not the plaintiff was operating his vehicle at the time of injury for the purposes of MCL 500-3135-2C. In particular, in our brief, we've cited to the House Legislative Analysis from December of 1995, where 3135-2C was enacted to correct the injustice of those individuals who did not contribute to the no-fault system for being allowed to collect non-economic damages. In that, there is not a lot of case law in terms of the definition of operation for the No-Fault Act. However, we've given examples based on the Michigan Motor Vehicle Code, as well as the OUIL statute, which I believe most aptly fits into the No-Fault Act, as well as the period of operation that was recognized in the unpublished per curiam decision of the Michigan Court of Appeals in Dewey versus Auto Club Insurance. After considering all of these definitions, I believe that adopting the OUIL statute's definition of operation, once a person using a motor vehicle has put a motor vehicle in motion or a position posing a significant risk of collision, such a person continues to operate until the vehicle is returned to a position posing no such risk. And when that definition is applied to the circumstances of this case, I believe that the Court can easily find that the plaintiff was operating his motor vehicle at the time of injury for the purposes of Section 3135-2C. Again, going back to our goals of statutory interpretation, obviously it's to give effect to the legislature's intent. Based on the information in the legislative analysis, in that we don't want, or the legislature did not want people who do not contribute to the no-fault system to be able to collect from the no-fault system, and putting this bar in place, I believe that the term operation should be interpreted broadly to encompass circumstances where people should have insurance on their vehicles and obviously not go out on the roadway and operate them. In this particular case, the plaintiff was driving from Standish and his vehicle eventually came to rest on the side of the road on US 10 in Midland, so for almost 50 minutes without insurance on his vehicle. And by all accounts, if the accident had not happened, he would have continued on to his home in Dansville, I believe is where it is. I recognize that there are different terms defined in different statutes for different reasons based on what the intention of the statute was, or specifically what the harm of the statute was intended to prevent. And given this circumstance, I think that if we take the OUIL statute's definition, which both looks at the actor's exertion of influence or physical control over the vehicle as well as the position of the vehicle, I think we can eliminate a lot of circumstances where we have this: was the engine running, was the person in the driver's seat, was the key in the ignition, those sort of circumstances, because it focuses on whether or not the vehicle is still in a position where it does not pose a significant risk of collision.
Does can you operate a vehicle that's inoperable? It's not functioning?
I would have to ask what the term non-functioning means, Your Honor. In terms of does the engine not run, does the transmission not work, can the vehicle turn on? I mean, those are the questions that I would ask in terms of whether the vehicle.
I mean, for a car, I guess it has a transportation function. Can you get the car to move from point A to point B under its own force without, you know?
I would say that you can do that, Your Honor, and
No, I mean, I'm not talking about this case yet. Like, I'm just asking. I'm struggling with this too, because it's about, you know, have to be operating your vehicle at the time the injury occurred. There's some allegation here. I'm not quite sure there's evidence, but there's some allegation here that the vehicle was not operable. So before we get to the evidence in this case, I'm asking you as a general proposition: can you operate a car or any machine or anything really that's inoperable, that's not functional?
Using a circumstance where there is a engine-driven machine such as a car or a piece of machinery, I would say that someone could still operate the vehicle if, for instance, they were pushing it down the road. If the engine ceased to function, for instance, and someone was pushing their vehicle to a gas station or even pushing it off the roadway onto the shoulder of the roadway.
Because they're controlling the movements of the vehicle?
I would say so, Your Honor.
I mean, at some point on the other end of the continuum, you know, if a person abandons their vehicle on the side of the road, they're not operating it, right?
Correct. And I would say even though that, and they're.
Or if you turn it over to a tow truck, a third party, then you're not operating it, right?
Correct, because you're no longer exerting influence, at least based on the definition of the motor vehicle code. You're no longer exerting influence or physical control of the vehicle at that point in time.
Here the claim is the truck cut out, I think was the testimony, and it was guided off to the side of the road. If the engine was completely dead and such that the car couldn't be operated and moved by its own power, could you satisfy this statute and show that the person was operating their vehicle if they're sitting in the vehicle? I mean, I assume if they get out of the vehicle, they're not, we wouldn't say they're operating it at that time.
Well, that poses another kind of issue because if the engine was running, for instance, and a person gets out of the vehicle, say to run in or because they dropped their keys, you know, to grab their keys and then gets back into the vehicle, that I think creates a different circumstance if somebody has a vehicle where the engine completely ceases to run and they're still in the vehicle. I guess it comes down to whether or not they'd be able to make the engine run again. I mean, maybe I'm not understanding your question correctly. If the engine is completely
I
dead.
don't disagree with you. I mean, if it's inoperable, that sort of the premise of the question is you can't pump the gas or do whatever somebody might do to, or get jumper cables and start the engine again. If it's inoperable, that means it can't be operated, right? That's almost by definition.
I would say so, in the circumstance that you gave, Your Honor.
And I'm just, I mean, some of this, as I was thinking about this case, may come down to whether there's proof that it was inoperable. It seems to me the evidence on that is pretty thin. There's an allegation that it was inoperable, but has there been any evidence to that effect in this case?
Just going by the testimony, Your Honor, the plaintiff states that that the vehicle had cut out, that it had died. That was his testimony. I asked
Didn't he also say at some other point in time that he pulled over to ask for directions or something?
That was a statement that he gave during IME examination that was contained in the report of the IME physician. So it's his statement. Was he asking for directions? And if so, was the engine operable? And if his vehicle actually cut out and he was unable to use it, he did testify that he was able to activate his hazard lights. He hadn't called for a tow truck or he didn't know what was wrong with the vehicle. There was some evidence from the police that there was fluid leaking, but whether that's wiper fluid, or oil or something else, we don't know at this point in time. But at this point, given the state of the record, he was able to activate the hazard lights on the vehicle as he stated. And with that, under the plain definition of operate, to cause to function, while it's not the primary function of the vehicle, he was able to cause that vehicle to function, at least activate the hazard lights. If we take that.
There's evidence the hazard lights were on?
We don't have evidence that the hazard lights were on him. It was just.
He indicated that
he indicated that he had activated the hazard lights. Again, he's found in the driver's seat. Had he been in the passenger seat, I believe he would have been crushed, essentially. So he was found in the driver's seat. He was not wearing a seatbelt necessarily. We don't know whether or not the keys were in the ignition. There's unfortunately a lot of facts that aren't here because of the way that the plaintiff testified and given the state of the vehicle.
But what makes this case different than a drunk driving case is, operating under the influence. When the police come upon a person, they're making sort of a look back. Was the person operating in the recent past? Usually, sometimes they'll come upon a person where they're in the driver's seat and the vehicle's running, and then you ask some other questions. But here we really are called upon to decide whether he was operating at the time of the injury.
Correct, Your Honor. And looking back, I would say that
I
the
mean, in
risk,
other words, it's clear he was operating, but like you said, he's in the driver's seat, the car got there somehow. In a drunk driving situation, you'd say, I think you have pretty good circumstantial evidence that he was the reason the car was where it was, right? He
Right,
got it to
and-
where it got to.
and I think that what's problematic with kind of parsing out these exceptions to the statute is that, you know, he's driving for an hour along the road, and all of a sudden, let's say he pulled over and called a friend on the phone, he shut the engine off, he just sat there on the highway talking to somebody, calling for directions, for instance. Does that automatically say that he's not operating under the statute? I mean, had he returned, for example, the vehicle to his driveway, and he's sitting in his driveway, the car's off, it's off the roadway, you know, I would say under the OUIL definition, that vehicle is not in a position where it would cause a significant risk of collision, as opposed to being on the side of the road, for instance, in this case. And that's a distinction, and I believe
Well,
that's why.
It's very interesting, because, you know, this is, I thought about this, does a person's operation of a vehicle coincide with the duration of their journey? That's kind of what you're saying. Once you're at your destination, you're no longer operating. But are you operating the whole time since you left point A until you get to point B? You know, for example, what if you pull into a gas station and you're filling your car up with gas? Are you operating the vehicle then?
I would say so, Your Honor, because I would, to back up, when the vehicle's pulled into the gas station, the engine turned off, somebody's outside the vehicle, and they're pumping gas, for instance, I would say that circumstance is right when he's out of the vehicle pumping gas, he's not able to push the vehicle in motion. It doesn't mean that the vehicle is necessarily in a position where it doesn't create a significant risk of collision, but it is in a position where it is less likely for there to be a collision. And, you know, people, you know, heavy traffic going in and out of a gas station, for instance, where a collision would be likely. But again, I think if we go back to defining the term in terms of the harm that the statute was intended to prevent, and the OUIL statute specifically, the collision between people who are intoxicated with persons or property, and the No Fault Act, compensating people for injuries as a result of collision with person or property. I think we get a lot of analogous terms here where we can use this definition and it doesn't go against some of our prior case law as well as other portions of the No Fault Act, specifically where a vehicle is in storage per se, and somebody's not required to have stored coverage on a vehicle where it's being stored. Same with a vehicle being repaired.
Does a person operate a vehicle when they're determining whether the vehicle is operable?
Say that one more time, Your Honor.
Are you operating the vehicle when you're determining whether the vehicle's operable? You know, what if you pulled off to the side of the road, your vehicle cut out, and now you're either trying to start it or, you know, pumping the gas pedal or doing something else to try to get the vehicle to start? Are you still operating it, or?
I would say that you are still operating it, and that's where the definition of operation goes. I'll finish up briefly, and then I see that my time is, I'll reserve the rest of my time for rebuttal, but that's where the Dewey case gets into, is the period that a person expects or intends the vehicle to be moved or driven on the roadway on demand. So did he expect the vehicle to be driven when he's cranking the engine to see if he can restart it, or put more water in a radiator, for instance? I would say so.
Yeah, so it has something to do with whether the person intended to continue operating the vehicle?
I would say that there is some subjective component as
So
to
maybe
whether
the gas scenario, the person's fueling the vehicle because they intend to continue operating the vehicle?
I would say so, Your Honor.
All right, sorry, I don't know why I wrote out like 100 questions in this case. I apologize.
Yeah, and so, counsel, actually, you know what, I'll wait till your rebuttal time. Never mind. Go ahead.
Good afternoon, Your Honors. Stephen Lovell appearing on behalf of the plaintiff appellee, Robert Whitney. Just briefly, I mean, we're here to look at one question, and that is how operate should be defined under MCL 500.3135C2. And I don't think there was really much confusion as to what operate means until that Dewey opinion came out, and I think that the Dewey opinion did conflate 500.31011, which has the language about the period a vehicle is being driven or moved on a highway, with the idea that this should apply to 500.3135C2. And I think the court should be disinclined to follow that logic here, because when we're looking at what the legislature intended, we know for a fact that the legislature, if they wanted that to be the standard, they knew all those words and they knew how to use them, and they could have just put them in 500.3135C2, and they didn't. So from that perspective, we know that really this isn't what the legislature intended. So talking about this period of time or this period of travel, I think takes it too far. I think the definition should be the dictionary definition of operate, to cause to function, and perhaps because we are in the context of the No Fault Act, to cause to function as a motor vehicle may be appropriate. And I think that, again, clears up a lot of the confusion caused by Dewey, which, I don't think there is a lot of confusion. There was a more recent Court of Appeals case that came out after briefing in this case, and that is the Finch v. Gewin. And in that case there, the Court of Appeals looked at this term operate, and there was a delivery driver who had parked at where he was delivering at a casino. He had put his vehicle in park. He was sitting in his vehicle. He reached down into his center console to grab something. He was going to go do his delivery, and in that time he was hit. And the Court of Appeals in that case said that he was not operating because he wasn't causing his vehicle to function as a motor vehicle. It wasn't going to be moved. It wasn't moving at the time. In this case here, and just to get a little more...
Your client intended to continue his journey, no doubt.
Certainly if he could, but he couldn't, because you had asked some questions earlier, and I think to get into specific on this, when it comes to whether his vehicle was operable, since we are the non-moving party and this was a motion for summary disposition, and the light needs to be taken, or the evidence needs to be taken in the light most favorable to plaintiff in this case, I think...
So what's the most favorable evidence you have that the vehicle wasn't operable?
That it died and it cut out, and that he had to coast it to the side of the road.
I mean, that could mean that it's inoperable, but it also could mean that it stalled out, and once he got over to the side of the road, he could start it again. Couldn't it? I mean, I'm no expert on auto repairs, but sometimes that's a permanent situation, and sometimes it's not, right?
Certainly, but then why stay there?
Did anybody ever, I know that there was a terrible accident after this, but did anybody ever evaluate the vehicle to see whether it was operable or not, or that's just not anything, or not worth the trouble?
No, there was no additional examinations of the vehicle after the accident. It's just my client's testimony that it died and he had coasted to the side of the road. I would say if he could continue his journey, he certainly would have. There'd be no reason to sit on the shoulder of a road.
Yeah, he intended to, if he could get his car going again, he would have continued on, right?
Yeah, he would have continued to operate it if he could operate it, but since he couldn't, he wasn't operating it, I guess is what I'd say.
What if, I was asking lots of scenarios about operating, what if whatever was wrong with his vehicle, I mean, it could be easily remedied. So what if your battery dies and somebody comes and is jump starting your car? Are you operating your vehicle while you're getting a jump start, or while you're waiting for the battery to charge so you can try to turn it on? Or is it only when you're in the car pressing the button, trying to get it to go? No, I was gonna say turn the key, but I guess that's become kind of outdated.
Yeah, right. Yeah, if you're sitting in the vehicle and you're going to put your finger on the button and then you get rear-ended and you haven't quite hit your finger on the button yet, right?
When are you operating?
Are you operating the vehicle? And I think under the plain language of the statute, you wouldn't be operating the vehicle at that point under that scenario. I think you have to cause it to function. And I think the reason that if we start expanding that definition, it's going to get murky, is because there was something said about...
If we're going to give a broad reading to a definition, this would be the place to do it, right? The idea is that people are supposed to have insurance, right? Everybody's supposed to carry their own weight under the No Fault Act. Isn't that the idea?
And I think, I don't disagree with that, but I think sort of bookending that idea or competing against it is the legislative intent. And so, like I said, we know that the legislature...
Of this specific provision, you mean? Or
of the No Fault
Act as a whole?
Well, that's what your question was directing.
We're going to prompt payment of benefits, which doesn't happen, right? Without litigation, that doesn't happen. But what other purposes are there? We want everybody to be insured. That apparently is not happening either. But so the Act doesn't seem to be working very well. But but everybody's supposed to pay for their, have insurance, right? That's certainly one of the major undergirding parts, points of the act, right?
It certainly is. And again, I think the issue that I run into when I'm just thinking through this, and I obviously thought a lot about this case, is when you're looking at the legislative intent, and we agree the No Fault Act sort of as a whole, that's the purpose. You have insurance, everybody pays into it. But we have the legislature enacting 500.31011 and having a broader exclusion there to being able to pursue benefits. And then we have 500.3135C2, and they don't. They just use the term operate. Again, there was nothing preventing them from using this broader language, and I think it does start to cause some issues when we're looking at expanding the definition of operate. There was something about, well, if you're turning on your hazards, is that operating the vehicle? Well, what if the passenger who was the owner, say the passenger was in a vehicle and the passenger was the owner, and then they hit the hazard lights and an accident happens, were they operating their vehicle because they hit the hazards and turned the hazards on? I'd say no. That's why I think you have to actually have, to cause a motor vehicle to function is to cause it to move or operate on the roadways. I don't think this period of time definition works, and I certainly don't think the OUIL statute should apply here. Again, we're dealing with sort of two very different things when it comes to the harm that drunk driving can cause compared to the harm of not having insurance. I really don't have much else to add other than that. I guess I would say that...
Let me ask you this question.
Yeah. Yes.
When did your client cease operating the vehicle? At what precise point in time, according to your theory?
When it stopped. When it was completely stopped. Because I would say that if he's coasting, he's still
So when it
operating.
came to rest?
When it came to rest, yes.
So you agree with opposing counsel that if he got out and started pushing the car, then he would be operating it again?
I wouldn't think so, only because of the fact that, well, that's a good question. I still wouldn't think that pushing the vehicle would be operating it, because the operation of the vehicle is it moving under its own power, but I think encompassed in that is coasting. Like if you take your foot off the gas and you're just coasting or you put it in neutral, I think the vehicle is still functioning as a vehicle. So here, if it's still coasting, coming out of its own power, I certainly think that could be operating. I think it'd be taking another step to say that pushing a vehicle is causing it to function as a motor vehicle. It seems more like you're just pushing a vehicle. It doesn't really seem like the vehicle's being operated at that point.
And then what if he coasted off the road, the vehicle comes to rest, he puts the vehicle in park, and 20 seconds later, he turns the key or presses the button and the vehicle starts? Was there a 20-minute break in operating?
I would say so. And I would say that's what the court in Finch v. Gewin recognized as well, is that he was parked waiting, or he was going to get out of his vehicle and do a delivery, but the vehicle was still on. He had just put it in park, and he was rear-ended, and the court said that's not operating because it wasn't causing it to function. And I think that's the same thing here. Of course, if he turned the vehicle back on and started it and was about to travel, I think at that point you are operating your vehicle. I think at that point you're getting into whether, it's a parked vehicle or not. It's tough. I think the easiest way for the court to address this here, though, is to, again, have the bright line rule as far as operate to just be the dictionary definition. And again, I don't think there was a lot of confusion until Dewey. It doesn't seem like the courts were having a lot of issues determining what operate should mean. And I think if it needed a broader definition, the legislature would have included that, or, like I said, used language that they used in other parts of the No Fault Act to sort of broaden that. And I don't have anything else unless there's any other questions.
Other questions? Okay, rebuttal? Thank you.
Thank you.
All right, counsel, I'll jump in real quick. This case is, because at least according to, the Court of Appeals, their ruling was there is this sort of fact issue, sort of under potentially any definition of operating. They sort of said, well, there's a fact issue, the jury has to decide that. What do we do about that in this case? It's not like, it sounds like the parties have not completely agreed whether the car was operable or not, depending on the definition.
Well, I would answer, Your Honor, by saying that we don't have a standard of what operation means for the purposes of this act in order to be able to determine whether or not there's sufficient facts to determine operation or not determine operation. which is why I think the OUIL statute maybe gives us the bright line standard in that circumstance. And just one example from what Brother Counsel was saying is that, you know, if the vehicle cuts out or if the engine stopped, you know, what if you're in a traffic jam? You shut off your vehicle because you're going to be stuck in traffic for an hour, and then all of a sudden a car 3 cars up comes behind you and hits the other car and behind you, and that car hits you, and you're in the middle of the roadway. You can't move, but you're in a position where the vehicle is in a significant risk of collision. You know, I would say that that is still operating, at least under the definition of the OUIL statute. There's also the issue of new cars nowadays that have an auto stop function. So someone sitting at a traffic light, the engine cuts out, and they're in the middle of the roadway sitting at a traffic light. They intend to proceed once the light turns green, and the engine turns back on at that point when they hit the gas pedal. I think if we start parsing out too many of these circumstances where the engine's running or not running, or, you know, it can be readily repaired, that kind of thing, I think that if, like I said, if we look at whether somebody has put the vehicle into motion, and I see that my time is up, Your Honor. Thank you.
Thank you both. The case will be submitted.